This video is going to cover the right to bear arms in cases from the United States Supreme Court. These are related to the Second Amendment. Most of the activity within the area of the Second Amendment and the right to bear arms has been of recent vintage, and there are two specific kind of focuses as we take a look at these, and that is whether or not the Second Amendment is in fact a collective right dealing with state militias, or if it is an individual right allowing individuals to bear arms. And the case before the Supreme Court has generally in the past been focused on the collective right, but what we've seen as the court has become more conservative in the post-Reagan era, we've seen that the Supreme Court has actually come down on the side of giving people individual rights to bear arms. So when we take a look at the cases in this section, we'll see the kind of the progression as we go through this. Now, part of the problem related to the Second Amendment and what it actually means is related to the wording of the amendment. And as you can see, it is somewhat strangely worded. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So those are two separate clauses that we see here. And in examining them, the question becomes which is more important, and does one preclude the other? And we'll see that discussion as we go through the cases. But just from this vantage point, we have what we can call the preamble or the prefatory clause, and then the operative clause. And a preamble is just usually the justification for why a right exists or why a law exists. And then the operative clause actually says what the right is. So as we examine this, the preamble says a well-regulated militia being necessary to the security of a free state. So that seems to imply that somehow the militia itself is what this right is about. The operative clause comes down on the side of saying the right of the people to keep and bear arms shall not be infringed, which may or may not be related to the preamble. If it is, then what we might see is a right to individual right to bear arms. But people that focus on the first part of the preamble, which is a well-regulated militia, say that the Second Amendment was written primarily as a way to be able to ensure the survival of state militias after the United States Constitution was written. And these existed during the Revolutionary War. There was concern among the anti-federalists, those that opposed the Constitution, that the federal government would become too strong and disband these citizen militias. So as a consequence of that, the argument is that this is a collective right to bear arms, that the federal government can abolish these state militias. On the other hand, those who argue for the individual right to bear arms focus in on the operative clause. The right of the people to keep and bear arms shall not be infringed. And if you kind of disassociate the operative clause from the preamble, that would imply that there is, in fact, an individual right to bear arms. So here's where the controversy comes in. And as we go through the cases, particularly starting with the case of the District of Columbia versus Heller in 2008, and then the more recent cases, we will see a very strict kind of divide between conservatives and Republicans on the Supreme Court, with the conservatives taking the side of the individual right to bear arms, whereby the liberal wing of the court has focused more predominantly on a historical meaning of the collective right. So let's examine a couple of these cases that are here. What we see essentially is that there isn't a lot of jurisprudence on this from the Supreme Court. And, the first really big case to test this was the U.S. Miller in 1939. And this was the consequence of the National Firearms Act of 1934, which was passed kind of as a consequence of violence dealing with prohibition, and the federal government basically got involved with the weapons, regulating the weapons for the first time. And the question at hand here was the National Firearms Act basically required certain types of lethal weapons to be taxed by the federal government, which they have the power to do so, and required their registration, and then also prohibited the interstate transport of these unregistered weapons as covered by the act, was illegal. So what we ultimately see here is the federal government's really kind of entering into the regulation of firearms for the first time. Question is whether or not they really have the right to do that, and that's what the court in U.S. versus Miller in 1939 did. Basically, there's a case in which Jack Miller and Frank Layton were caught carrying arms across state borders, and basically they had a sawed-off shotgun. And the question was whether or not they had the right to have this shotgun, which was covered under the prohibited weapons in the National Firearms Act of 1934. So basically what we saw here was that the argument is that the Second Amendment really is only it preserves the right to be able to have weapons that would be used in a state militia. And the argument was that this sawed-off shotgun was not of the tradition that people would use in the militia. Therefore, the argument from the United States side was that this would be constitutional to regulate this. And what we saw was that, in fact, the Supreme Court was united in a unanimous decision and sided with the idea of a collective right. The court concluded the Second Amendment was designed to cover only military-style weapons associated with state militias. And here to quote Justice McReynolds, who wrote the opinion, "In the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relation to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Certainly it is not within judicial notice that this weapon is any part of the ordinary military equipment or that it could contribute to the common defense. With obvious purpose to assure the continuation and render possible the effectiveness of state militias, the declaration and guarantee of the Second Amendment were made. It must be interpreted and applied with that view in end." So U.S. versus Miller in 1939 sets really the precedent by the Supreme Court that this is a collective right, and people have the right to have weapons that can be used in state militias. If they are not, then people do not have the right to carry them, and they can be regulated. Right? So what we see, though, is gradually through time, the conservative movement, for the most part, latches on to the idea that this is an individual right to bear arms and not the collective right. So fast forward, ahead 71 years, I guess we can say, to the District of Columbia versus Heller, which is in 2008. And in this decision, the question is whether or not the District of Columbia can have a ban on handguns by private possession of individuals. As we look at this case, as we will in the forthcoming cases, what we will see is a very narrow divide in the Supreme Court between the conservatives and the liberals in the court. So if we look at DC versus Heller, it's a 5-4 decision. And what we see in the majority is Alito, Kennedy, Roberts, Scalia, Thomas versus Breyer, Ginsburg, Souter, and Stevens. The classic 5-4 decision split down the middle between the conservatives, who are in the majority, and the liberals, which are in the minority and will be in the dissenting opinion here. So Justice Scalia gives us the opinion in court in this case. And what we see is Dick Heller is a security guard at the Federal Judicial Center. He has a right to be able to carry a firearm while he's on duty, but he was refused a permit to be able to own a handgun for his own personal self-defense. He takes that to the Supreme Court and basically says this violates his Second Amendment rights to be able to possess firearms. So what does the court decide in this case? Well, the case that we see here in Scalia's opinion really kind of breaks down the case into two separate areas, again, looking at the operative clause and the prefatory clause, or what we call the preamble, and then how they apply to each other. So let's take a look at some of his wording as we go through here and take a look at District of Columbia versus Heller. So he says the Second Amendment is naturally divided into two parts, its prefatory clause and its operative clause. The former does not limit the latter grammatically, but it announces a purpose. And what's interesting here is that Justice Scalia, in his opinion, actually kind of rewords the Second Amendment to make it a little bit more clear, which is relatively interesting. He says, we could pretty much say that this is what the amendment means if we were to rephrase it. Because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And that's kind of a modern day version of what the Second Amendment would say. And he says, logic demands that there be a link between the stated purpose and the command. Let's take a look at what that actually means. And interestingly enough, he starts with the operative clause before he discusses the prefatory clause or the preamble. And there's kind of a logical reason for that, and when you break down his decision. So he says, the right of the people, right? The right of the people is the first salient feature of the operative clause. The unamended Constitution and the Bill of Rights use the phrase right of the people two other times. In the First Amendment's Assembly and Petition Clause, and in the Fourth Amendment's Search and Seizure Clause. All of these instances unambiguously refer to individual rights, not collective rights, or rights that may be exercised only through participation in some corporate body, right? This contrasts markedly with the phrase the militia in the prefatory clause. The militia in colonial America consisted of a subset of the people, those who were male, able-bodied, and within a certain age group. Reading the Second Amendment as protecting only the right to keep and bear arms in an organized militia, therefore, fits poorly with the operative clause's description of the holder of that right as the people. So, in other words, what he's saying here basically is that the people were really the average male citizen that could pick up arms if necessary to join a militia. Arguing that this was an individual right of those people. So the question then becomes, how do we talk about the terms keep and bear arms? So again, he's interested in defining what these mean. What does the word arms itself mean? And what does the word keep and what does the word bear means? So in talking about arms, he said that the term was applied then as now to weapons that were not specifically designed for military use and were not employed in a military capacity. Interesting, right? How about the terms keep arms and bear arms? We define keep as most relevantly to retain, not to lose, and to have in custody. Thus, the most natural reading of keep arms in the Second Amendment is to have weapons. Right? What does it mean to bear? He says, as at the time of the founding, as now, to bear meant to carry. Now, what's interesting here is he quotes Justice Ginsburg's definition of the idea of what bearing arms means. Now, of course, Justice Ginsburg is in the dissenting opinion in this case, but it's kind of a little tete-a-tete there between Scalia and Ginsburg. And says, Justice Ginsburg says in the case Muscarella versus U.S. 1999, that surely a most familiar meaning, as the Constitution's Second Amendment indicates, wear, bury, or carry upon the person or in the clothing or in the pocket for the purpose of being armed and ready for offensive or defensive action in the case of conflict with another person, right? So essentially what this says is that you have it for the right of self-defense, and Scalia says it in no way connotates participation in a structured military organization. In other words, it is an individual right to bear arms. It has nothing to do with the militia, right? So He also says, at the same time, let's take a look at what this meant when we take a look at constitutions of the states at that point in time. And here again, kind of this polling of jurisdictions. The most prominent examples are those most relevant to the Second Amendment. 9 state constitutional provisions written in the 18th century or the first 2 decades of the 19th enshrined a right of citizens to bear arms in defense of themselves and the state, or bear arms in defense of himself and the state. It is clear from those formulations that bear arms did not refer only to carrying a weapon in an organized military unit, right? Again, he finds that this is an individualized right, and kind of closes off this discussion of the operative clause by saying there seems to us no doubt on the basis of both text and history that the Second Amendment confirmed an individual right to keep and bear arms. All right. So what does he mean by the prefatory clause? In other words, what's that well-regulated militia mean? And he wants to make a differentiation here between the military, that's in Article 1 of the Constitution, which is the right of the federal government to raise a military, and then the militia clauses. And basically, the separation here is that there was concern that the federal government would somehow disband the state militias, and they are different substantially from the U.S. Army or the regular army that we would talk about. So what's the kind of relationship between these? So as we read Scalia's opinion, does the preface fit with an operative clause that operates an individual right to keep and bear arms? He says it fits perfectly. Once one knows the history that the founding generation knew and that we have described above, that history showed that the way tyrants had eliminated a militia consisting of all the able-bodied men was not by banning the militia, but simply by taking away the people's arms, enabling a select militia or standing army to suppress political opponents. And he goes back and talks about the debates during the Constitutional Convention and the concern by the anti-federalists that the federal government would disband state militias and rule over the United States with a standing army, and basically makes the discussion that what this is really referring to is the idea that people be prepared to be able to go into their militias in order to be able to defend themselves and their rights from perhaps a government that is trying to take them away. So from that perspective, basically says that, this is an individual right. And what's interesting here is he says, like most rights, the right secured by the Second Amendment is not unlimited. What might be something that would be regulated? He says, although we do not undertake an exhaustive historical analysis today of the full scope of the Second Amendment, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. So, there is the ability to be able to regulate. It is not an unlimited right, but it is an individual right. The inherent right of self-defense has become central to the Second Amendment right. The handgun ban amounts to a prohibition of an entire class of arms that is overwhelmingly chosen by American society for that lawful purpose. The prohibition extends moreover to the home, where the need for defense of self, family, and property is most acute. Under any standards of scrutiny that we've applied to enumerated constitutional rights, banning from the home the most preferred firearm in the nation to keep and use for protection of one's home and family would fail constitutional muster. All right. So, individual right, majority, 5-4 conservatives, District of Columbia versus Heller. And, essentially what Justice Stevens says in his dissent, which is joined by the other liberal justices, he says, essentially taking the argument from Miller. And he says, neither the text of the amendment nor the arguments advanced by its proponents evidence the slightest interest in limiting any legislature's authority to regulate private civilian uses of firearms. Specifically, there's no indication that the framers of the amendment intended to enshrine the common law right of self-defense in the Constitution. Again, this is just a collective right related to state militias, right? And then they go on to say, this case of Miller was basically heard in 1939. We've had this precedent. It's now 2008. Why is it that all of a sudden today, the court decides to create this new right without any respect whatsoever for precedents, without any new historical unveiling of facts? The court's announcement of a new constitutional right to own and use firearms for private purposes upsets that settled understanding, i.e. from Miller, but leaves for future cases the formidable task of defining the scope of permissible regulations. The court would have us believe that over 200 years ago, the framers made a choice to limit the tools available to elected officials wishing to regulate civilian uses of weapons. And basically, Stephen says, I can find nothing in the Constitution or history that would subscribe to that fact, right? So, again, this notion here by the conservative majority in District of Columbia versus Heller gives an individual right to have arms. This is an interesting question because when we take a look at this, the District of Columbia is different than states. It is run technically by the federal government under the auspices of the federal government, which controls it. So how applicable was DC versus Heller to the states? Not necessarily. So what we see is a second case comes along 2 years later in McDonald versus City of Chicago, in which basically handgun possession was banned by most private citizens. In this case, what we see again is in that 5-4 majority, this time with Justice Alito writing for the conservative majority, basically incorporated the Second Amendment onto the states vis-a-vis the 14th Amendment. So that individual right is now a right that is incorporated onto the states. So in looking at this again, in McDonald, as did Justice Scalia in District of Columbia versus Heller, he stresses that there are some types of regulation that can be, allowable under the Second Amendment, and they're basically the same ones that were mentioned in District of Columbia versus Heller. And that gets us to our most recent case, and in this case, New York State Pistol and Rifle Association versus Bruin. This was argued in 2020. And once again, in this case, this now being a 6-3 majority, again with Justice Ginsburg having passed away and been being replaced by Justice Barrett. It's conservatives again versus liberals. So in the majority is Alito, Barrett, Gorsuch, Kavanaugh, Roberts, Thomas, and in the dissent is Breyer, Kagan, and Sotomayor. And in this case, New York basically required a person to show proper cause before they could carry a concealed weapon. So it wasn't just that you showed up and you applied, and as long as you met the qualifications for having one, you'd automatically get a license. You had to show a special need for self-protection distinguishable from that of the general community. So Justice Thomas, in this case, is the one that delivers the opinion in the court. He says in DC versus Heller and McDonald versus Chicago, we recognize that the Second and 14th Amendments protect the right of an ordinary, law-abiding citizen to possess a handgun in the home for self-defense. In this case, petitioners and respondents agree that ordinary law-abiding citizens have a similar right to carry guns publicly for their self-defense, right? So the other cases were, used within your home. Now the question is, do you have a right to be able to carry firearms in public? And basically, they said yes. Today, we decline to adopt the approaches that have been used. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that regulation is consistent with this nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Right? And then in this case, the two people that were denied the license to carry a concealed weapon, basically, they find nothing in the Second Amendment that draws a distinction between home and public as far as your right to carry arms, and the guarantee extends then to outside of the house as well. So it says the Second Amendment's plain text thus presumptively guarantees petitioner Koch and Nash a right to bear arms in public for self-defense. And he says there's no historical precedence for anything like New York's law. So again, goes back to Heller. It says under Heller's text and history standard, the proper cause requirement is therefore unconstitutional. It prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. Right? Again, you have to show under the New York law that you have a special need to have a concealed weapon. And basically what Thomas is saying here is everybody's got the right to carry the weapon. You don't need to have a separate need. Therefore, it's obvious that this is in violation of the Second Amendment. Now, again, the smaller liberal majority in this court case does not obviously agree with that. And really, kind of at the base of this is the idea of they don't believe that the Constitution is stuck in 1789. Right? And that there has to be some movement of applying the Constitution to the situations as they exist currently at that time, which is 2022. So they, Justice Breyer starts off with, some statistics about people killed by firearms. It says many states have tried to address some of the dangers of gun violence just described by passing laws that limit in various ways who may purchase, carry, or use firearms of different kinds. The court today severely burdens states' efforts to do so. And Justice Breyer says there's a number of reasons why the court was seriously wrong in the majority opinion. First, the court wrongly limits its analysis to focus nearly exclusive on history, refuses to consider the government interests that justify a challenge gun regulation, regardless of how compelling those interests may be. In other words, there's no balancing test here, is essentially what Justice Breyer is saying. That the government sometimes has a reason for doing stuff in our ordered system of liberty, right? He doesn't mention ordered system of liberty, but that's kind of what he's getting at. The Constitution contains no such limitation, and neither do our precedents. Second, the court itself demonstrates the practical problems with the history-only approach. In applying that approach to New York law, the court fails to correctly identify and analyze the relevant historical facts. Only by ignoring an abundance of historical evidence supporting regulations restricting the public carriage of firearms can the court conclude that New York's law is not consistent with the nation's historical tradition of firearm regulation. So basically saying they're wrong. Second of all, they say, hey, are we historians? No, we're judges. What do we know how to do? It says judges understand well how to weigh a law's objectives, quote unquote, its ends, against the methods used to achieve those objectives, quote unquote, its means. Judges are far less accustomed to resolving difficult historical questions. How will judges determine which historians have the better view of close historical questions? Will the meaning of the Second Amendment change if or when new historical evidence becomes available? Most importantly, will the court's approach permit judges to reach the outcomes they prefer and then cloak those outcomes in the language of history? To which he goes on and says, "We were a rural nation in 1790. Even the city of New York itself only contained 33,000 people. Small founding era towns are unlikely to have faced the same degrees and types of risks from gun violence as major metropolitan areas do today. So the types of regulations they adopted are unlikely to address modern needs. Because I cannot agree, this is the way Breyer closes, because I cannot agree with the court's decision to strike New York's law down without considering the state's compelling interest in preventing gun violence and protecting the safety of its citizens, and without considering the potential deadly consequences of its decision, I respectfully dissent." So what we see here then is again this divide, um, with the court saying that we need to balance safety versus Second Amendment rights, whereby for the most part the individual right trumps everything else when it comes to the conservative majority. So that's where we're at this point in time. And that's the jurisprudence of the Second Amendment as we stand. Uh, and very interesting decisions here, very split along ideological lines. And of course, there continues to be an ongoing problem in American culture. And it will be interesting to see how all of this gets resolved.